So hi guys, just want to welcome everybody to the Understanding the Litigation Process when Making a Claim on Behalf of a Child webinar. I'm going to hand over to Sarah and Lauren, and we also have Samantha, who is a mum, and her case manager, Kate, as well, who's going to be talking to us along the way. So I'll pass over to you now, Sarah, if that's okay.
Thank you, Jade, and thank you to the rest of the team at SNAP for inviting us along today. This is actually going to be the first of 4 Q&A webinars on the life of a legal claim and understanding the litigation process when making a claim on behalf of a child. We're mindful that there's a lot of information out there. I'm going to try and make it as accessible as we can. Just forgive me if my slides are a little bit slow. I'm controlling the screen, but here we go. So my name's Sarah Griggs. I'm a partner in the serious injury team at Irwin Mitchell, where I've been for the last 15 years. My specialism is representing children and adults who sustain a traumatic brain injury, mainly following a road traffic collision. My colleague Lauren Hurney, who's with me today, is also a partner, and she specialises in medical negligence claims. And as Jade said, we're joined by Sam, one of Lauren's clients, and Kate, who's a case manager who I've been working with on a paediatric case recently. Why bring a claim? It's really important to sort of understand what we can do in the litigation process. And we appreciate for medical negligence cases that often families just want to find out what's gone wrong, who's at fault, and they want to make sure that mistakes aren't going to be repeated. People often want an apology, and whilst we'll try really hard to get that, that's not something that we can guarantee. Ultimately, the law can only provide compensation. And whilst the money can't reverse the position that the child's been put into, it can be used to pay for medical care, rehabilitation, and to ensure the family is financially secure, and also to make sure that child has the best quality of life available. We can't turn back the clock, but we can use the legal process as creatively as we can to really try and get the rehabilitation in place. There's also a possibility to request what we call interim payments whilst the claim's ongoing. That's basically a payment on account rather than a pot of money at the end of the case that can then be used to fund vital therapies and case management, all things that a child may need. So when can you make a claim? Are there time limits? So for an adult, you've got 3 years from the date of the injury to bring a claim at court. So that's to actually issue court proceedings. So you don't want to be leaving things right up to that 3-year time limit, because you need to get on board with your solicitor and start the process going. For a child, that 3-year doesn't run until their 18th birthday. So the eve of their 21st birthday is the last date you have to issue court proceedings. If a child or an adult has been so severely brain injured they can't follow the legal process and are deemed to what we call lack capacity, then that time limit doesn't run at all, okay? So we assess all of that at the beginning of the claim when we meet the child and their parents. Now, this is the thorniest aspect of a case, choosing your solicitor, and you've really got to make sure it's someone who you trust. As Lauren and Sam are going to go into, this can be a very long relationship. And you've got to have a solicitor who not only has the specialism in the area, but also that rapport and that understanding that you're going to have together. It's really important that you ask that potential solicitor questions about their experience. Don't be afraid to probe. This is going to be a very long relationship, so you've got to trust that person. Ask what kind of cases they've worked on before. Do they have similar experience? Have they got any client testimonials they can share? Do they have relationships with charities and organisations who can help you through what you're going through? I would always recommend that you meet more than one solicitor as well. I settled a long-running case last Friday. I had an approval hearing in court. It wasn't a child case, it was a 19-year-old lad whose case settled. And his mum said to me at the end, you know, is our relationship going to end now, Sarah? He'd been in 3 different care homes. We managed to get him into independent living. We'd had 4 different case managers through the life of the claim, and he'd had lots of different therapists. And she said to me, you have been the one constant in his life for the last 8 years. So that is, it is really important that you're comfortable. Another really key question that people ask is funding. How is a legal claim going to be funded? And there are 4 main options, which I'll go through now. The first is a conditional fee agreement, which is what it says it is, and I'm sure lots of you will have heard of them, a no-win, no-fee. It is what it says it is. And if your solicitor spends a lot of time investigating a case and ultimately advises you that unfortunately they don't think they could take the case on, they can't charge you anything for those investigations. So it is in the client's best interest. There is also the option of legal aid. Now, unfortunately, it's very limited these days, and you couldn't get legal aid, for example, for a road traffic collision. But you can have legal aid still available in a case of a child who's had a severe disability as a result of a neurological injury. So it's always worth talking to your solicitor about that and that kind of claim. There can also be something called legal expenses insurance, which from my experience, lots of my clients don't even know they've got. You can have this attached to a household or motor insurance policy, which can give you access to a certain cap level of legal support. So it's always worth checking that as well. And finally, there is an option of trade union funding. If you're a member of a trade union and pay your regular subscriptions, you may have access to their legal team. So it's, again, if you're a trade union member, it's worth looking into that. So what is the law? How do we prove a claim? And the basic principles are, is there a duty of care? Has that duty of care been breached? And has that breach caused the injury? So for a medical negligence claim, and there's some case law attached here, some very specific cases regarding negligence claims against doctors, a doctor has a duty of care to their patient. In a road traffic collision, all road users have a duty of care to other road users. So has that duty of care been breached? And then has that caused the injury that's been sustained? And the claimant has to prove that that injury was reasonably foreseeable as a result of that negligence. So investigating a case, how do we get started? Now, the first really important meeting is the initial client meeting. And as I've just said, when you're choosing a solicitor, don't be afraid to have a first meeting with a couple of solicitors to make sure you're comfortable. That meeting would always usually be at a client's home pre-COVID. I have met with clients in hospital if that's been their preference. And I've had some clients who just want to keep everything away from the family home and want to come to my office. We're entirely guided by our clients what works for them. And at that initial meeting, we'll talk about funding options. We'll also talk about the evidence that we need to start gathering in to prove the claim. So, for example, getting in medical records, obtaining various reports, medical negligence cases. If a child's been injured in a road traffic collision, contacting the police, getting their reports, any witness statements, CCTV footage, all that kind of initial evidence gathering that we need to get on with the claim. We also sometimes instruct experts at a very early stage of the case to help us work out who is to blame for the accident, and I'll go on to that in a bit more detail in the next slide. There is also what's called a pre-action protocol, and that's in place for both clinical negligence claims and serious injury cases. And that's a sort of timetable that's set by the court for how we're supposed to work with the defendants to get the case ready to go to court if necessary. And then if we're not able to settle or we can't proceed the case, we commence court proceedings. That's often a part of the case where my clients get very nervous because the idea of going to court and going before a judge is very daunting. We don't always issue court proceedings because a case is very, very difficult and we're anticipating a full-blown trial. Sometimes it's just good to get it in that court process and have a court master overseeing it so that you can get a good timetable in place to move things forwards. It can also help if you need to make an application for, say, an interim payment, or you need some part of a settlement approved. So for a child's case that could go on for a number of years, you may resolve the issue of who is to blame before you work out how much the case is worth. So you might need to get a section of that case approved. So in terms of experts, they're really, really important in both serious injury and medical negligence cases. We often instruct them in the early days to work out who's at fault, especially with medical negligence cases, because they can be very, very tricky. But the expert's duty is to the court, and that overrides any obligation to the client or to the solicitor who instructs them. Ultimately, they have to give their evidence in front of a judge at the end of the case, and they have to be satisfied that their opinion is the correct one. So we'll often approach them at an early stage of a medical negligence case to work out if there is a case. Has that duty of care that I talked about been breached? And they would go to a paediatrician or a paediatric neurologist, a number of different people. In a serious injury case, we may go to an accident reconstruction expert, usually a former police officer, who would work out how the accident happened and look at real specifics such as a speed vehicle, could it have been avoided, so as to help us with any difficult liability. I say, sorry, I'm using legal speak, and liability means blame, to help us work out who is to blame. So they're very important, the experts in the case. And then moving on, once you resolve who is to blame, they're then very important in working out the value of the case, as the next slide will show. How we work out compensation in this country is it's separated into two elements. General damages, that's for the injury itself, and special damages. So the general damages are the compensation for the injury itself. And we follow guidance set by the court in relation to that. And the guidance is set, and it's quite remarkable, really. It's broken down into brackets, very specific. So for a broken finger, a fractured leg, to the various different aspects of a brain injury, moderate, severe, very severe, and brackets of compensation are set for that. But then the other side of the compensation is what we call special damages. And that are those very specific items that can be claimed as a result of the serious injury. So, for example, past losses, the care that a family has provided, the case management, travel expenses, any equipment that's been needed to purchase, such as a wheelchair. And then we look to the future, what future losses can be claimed. And this list isn't exhaustive, and obviously every child is an individual and going to have their own needs. But again, we would use specialist experts in their field to help us with this. And we can often have to use a number of experts to help us work out the value of a severe traumatic brain injury case, because they can only give evidence in respect of their specialism. So if you had a child with both a brain injury and a broken leg, you'd need a report from an orthopaedic surgeon, but they couldn't comment on the level of the brain injury. So they've got to be very specific in their fields. And some of these heads of loss can really be very expensive for a child for the rest of their life. So, for example, if a child needs 24-hour care 7 days a week, the care claim is probably going to be the highest aspect of the claim, which we're going to need very good expert evidence to help us to value. That's my bit. I'm now going to pass over to Lauren, but I'm going to be here to answer all the questions at the end.
Thank you, Sarah. I'm just going to go through a bit more detail of some of the things that Sarah has discussed, certain things that might come up and might be relevant if you're ever thinking about investigating into a claim. So as Sarah said, I specialise more on the medical negligence side of things. So one of the main things that you may hear about is something called an HSIB investigation or HSIB report. So just going through that a bit more, who are HSIB? Effectively, they are a health and safety investigation branch. They have been specifically set up to look into any case that may involve an incident where something has gone wrong during labour. And there is a very specific criteria for HSIB to pick this up. So just going through that, it's in relation to all term babies that are born at 37 plus weeks. They have either not survived the labour, they've either died within the first week of life, or they've suffered a potentially severe brain injury. So moving on from there, the purpose of their investigation is then to look at what may have medically gone wrong, what may have gone wrong in the environment, what may have culturally gone wrong in that environment that had led to any of these things happening. Many people sometimes are a bit concerned of what to do next. Do they wait for the outcome of that report and investigation, or do they come and instruct solicitors? What we would normally advise is that it's entirely up to you. There isn't a wrong or right answer to that. It can sometimes help if you have gone through that investigation process already. However, saying that, I have seen many investigations that have come back and they have identified certain failings, but then when it comes to the actual clinical negligence claim, issues have been raised in relation to the test that Sarah was talking about of causation. So effectively, it hasn't really sped up the process by waiting for that report to come through. So in my experience, it is normally worth at least speaking to a solicitor if you know that that is going to happen, getting some initial guidance from them, and then again, deciding what you want to do at that stage. So moving on from that, what are the common challenges that we face in paediatric cases? So the first and often the most difficult is getting all of our experts to assess what the prognosis is. So as you can appreciate, we have to try and work out what a child may need for the rest of their life. So that could be another 60, 70 years plus. The difficulty is that when a child is quite young, they obviously still have a lot of growing up to do. As Sarah's explained, we have quite a lot of experts that are involved in the case, and we are quite heavily led by what they tell us. So the difficulty we can often face is that it's hard for those experts to tell us what they think the prognosis is going to be. So it might be that they see a child, they come back and they give some predictions, but they'll quite often say to us, I'd like to see this child again when they're maybe 8 or 10, and then I'll make a better conclusion as to their prognosis. So again, we're effectively led by that. And sometimes that does mean that we then have to wait quite a long duration in order to be able to figure out where a case is going. The other difficulty running alongside that, life expectancy can sometimes be a challenge. It obviously isn't a nice topic to have to think about, but it can sometimes create a bit of friction between assessing that prognosis and trying to settle the case quickly, but yet not trying to settle it so quickly so as we get something wrong, because you only get one chance at this. Once something's settled, you can't normally come back again. So it does present a bit of a challenge of trying to work out when is exactly the best time to actually try and settle a claim. One of the other things then that we have to consider, again, thinking about prognosis, is sleep and how many carers someone might need. Now, these two are actually, they exist together. So the problem with sleeping patterns is that is quite often a problem with many children, but that does have a massive impact on quite a lot of paediatric cases, due to the fact that if they require somebody to be awake with them all through the night, that is going to add a lot of value to the claim. And if we get that wrong, what can then happen is that there isn't enough money to then support the care package that's needed. So that sort of ties into what we're saying about how many carers are needed in the future. So we have to carefully assess what the position is throughout a child's life, looking at the course of their development over many years to try and work out exactly what they are going to need for the rest of their life. As a slight side point, we also have to think about their education, their EHCP, which is their educational healthcare plan. That does have importance to the case because we need to make sure that that education is provided. And if it's not going to be provided by the state, do we have to think about whether it can be provided on a private basis? Quite often we have to involve our public law team to help us out with that, to potentially challenge or review those decisions so we know exactly what is going to be provided by the state or not. The other common challenge that a lot of parents sometimes find difficult to understand is the structure of these settlements. So a lot of the time, most of the parents come to me and they're very keen to have all of the money all together in one lump sum. That actually isn't normally what we advise most people to do. What would normally happen is we would be advising people to get a lump sum for most of the needs. But when it comes down to the care and the case management costs that someone's going to need for the rest of their life, we recommend that is made on an annual payment that continues to be received for as long as they're alive. So that negates any issues that we might have had with the life expectancy as well. So even though you might not have all that money all together, it actually definitely is in the interests of you and the child to have it on an annual basis and not just in that lump sum. So then moving on from pure litigation, one of the things that we take very, very seriously is rehabilitation during the process of litigation. So I'll talk about this in a bit more detail on the next slide, but just as a bit of an overview, rehab obviously is really important. And what we like to try and do is get early interim payments so then we can then think about purchasing any aids or equipment or therapy, making sure that the access to private therapy is there if it's needed. Again, as I said before, making sure the right access to education is there if it's needed. As we'll explore a bit when we speak with Kate, choosing the right case manager is really important to make sure that the family is supported through the clinical side of things, not just the litigation. At Irwin Mitchell, we offer a client liaison manager, which is very similar to a case manager, but is more involved when the issue of liability. So has the hospital, has the insurer, has someone admitted something has gone wrong? That doesn't always happen straight away. So when we can't get that admitted soon, we then involve our client liaison manager who can step in and do bits and pieces on the clinical side just to help progress matters along while we're concentrating on the litigation. And obviously at that stage, we would be looking to involve people like Snap Care to come in and provide that specialist care to our clients to make sure they're well supported and looked after. So as I said, just going into a bit more detail about interim payments. So they are effectively payments that you receive along the course of a case. The slight difficulty with these is that we can only get access to these once liability has been admitted. So as I said, once someone has said that they've done something wrong, that's when we can start accessing these payments. Unfortunately, that isn't always possible from the very beginning, and sometimes you can be going through litigation for years and years before you even get to that point of getting that admission. So we obviously push and get that admission as soon as we possibly can to access these interim payments. Just to explain a bit how they can help is that they can then pay for a case manager like Kate, who will effectively come in, help to manage both sides of the clinical input as well as the legal input, and make sure that both sides are effectively talking to each other. We're getting the right documents to and from each other, and just generally making sure that the family are really supported in that whole process. Again, as I said, we then involve support workers where possible, just to help provide a bit of additional assistance. So this isn't in any way an attempt to try and remove the parental support that's being provided. It's just to try and make sure that mum and dad can go back to being mum and dad, and that paid support is there just to help them. A multidisciplinary team, or an MDT as you might hear it called, is just basically lots of therapists. So normally it would be an occupational therapist, a physiotherapist, neuropsychologist, all being involved together to try and assess what that child needs to help them, and reviewing and looking at goals along the way. So just making sure that everybody is on track, making sure the support workers know what they're doing, and equally then your case manager would be involved in that MDT to make sure that everybody is working together collaboratively. And then finally, the other thing to look at with interim payments is accommodation. So quite often, to put all of those things into practice, you need a lot of space to do that. So it normally means that most families have to move out of their current home, normally into a rented property while the litigation is ongoing. In some circumstances, we might be able to buy a home, but that is quite rare while the case is ongoing. So we would normally look to rent somewhere that would allow both support workers and carers to potentially live in the home if that's what's needed, if, for example, night care is needed. Also to allow a therapy room to be put in, sometimes a sensory room, and just to allow the space that's needed for all of the necessary bits of equipment. Then just going through a few commonly asked questions when people are starting out in litigation. As Sarah sort of touched upon, when it comes to funding, people are quite worried that they're going to have to pay something. That isn't the case. What I would say, though, is that it is important to check and ask that question depending on which solicitors you go to. At Irwin Mitchell, we reassure people that from the very beginning, they're at no financial risk whatsoever when it comes to investigating a claim. Depending on the funding route you go down, there may be, if you use a no-win, no-fee, some fees that are payable at the end. But again, your solicitor will be able to break down and explain to you how that would look and what you're likely going to be anticipating paying at the end of the case. What happens if you lose the case? Again, in all those situations, no matter what the funding, it should be the case that you're at no financial risk whatsoever. So there should be various mechanisms in place to protect you completely, to ensure that you can investigate that claim without any worries. Will you have to give evidence at court? The short answer is yes, we have to prepare you for that. What I would say is it's probably less than 1% of cases that ever do go to trial, but obviously that is what we're working towards if we can't get an agreement with the other side. So there is a potential that people will have to give evidence, the experts will have to give evidence, and potentially even the therapists or case managers that have been involved as well would have to give evidence to help support the claim. The other big question I always get at the beginning is whether or not, especially in relation to medical negligence, it will affect the medical treatment that the child is currently having. And the answer is no. I've never experienced any issues or any concerns being raised if the child continues to have treatment at that hospital. The reality is that these types of cases are all dealt with something called the NHS resolution. So it is slightly removed from the day-to-day clinical care. So it shouldn't really worry you or give you any concerns or worries that this is ever going to affect any hospital treatment. So just trying to put all of that into a nice example, what we've got is a case study, which is actually one of Sarah's clients, just to show how all of this works in practice. So hopefully I will do it justice. I'll have to refer to my notes so I know all the specific details. But effectively, this involved a client who was hit by a car while he was on his scooter in February 2019. He was taken to hospital initially, where they did a CT scan of his abdomen and also a scan of his elbow and his ankle, but he was then subsequently discharged. He then began to experience a lot of pain and went back into hospital the following day, where they did do a scan of his head, which did show that there was a bleed, which was creating pressure on the brain. This meant that he did need to have emergency neurosurgery to relieve that pressure, and that was all successful, which was great. The problems, though, really became apparent when the client went back to school. So it was evident at that stage that he wasn't quite meeting the same milestones as his peers. He had been put in contact with a community therapy team at the Children's Trust, who had been able to put in place some therapy for him. And also at that point, when it was discovered that there were some problems at school, offer some training to the teachers as well to make sure that everybody fully understood exactly what this child needed and how he could be properly supported. As I discussed above, there were some issues here that we did have to involve our public law team with as well in relation to his education. So we did need to look at and appeal his EHCP, which was, I'm pleased to say, successfully done, which was a great outcome. And I think the important thing, and what's really great in this case, is that the child has actually managed to go back to secondary school. He started last September, which was a great result and just shows the use of putting in place all that private therapy, making sure that everybody is talking together, making sure that all of the needs identified have been filtered down through the various systems. So in this case, from therapist down to teachers, to make sure that that child is completely supported. I think I'm right in saying that that case is still ongoing, and I believe that it's actually Kate that is his case manager. So you'll be hearing from Kate later. Yes. What I'm going to do now is just hand over to one of my clients, Samantha. So we've been working together now for quite a few years. I'll let her explain a bit more detail, but it's been a long process, but we have made good progress. Just to explain a bit of background, so we have now been through the process of going through that initial litigation of deciding who's at fault. That did take quite a few years for us to get to. So we are just at the position now where we have got interim payments, we have got a case manager, and we are looking to put in place all of the therapy. But I'll just hand over to Sam and let her explain to you how she's found this process.
Hi, Sam.
Hi. As Lauren said, we've been working together now for, 11 years. She didn't say exactly how long, but it's been 11 years, so it's been a long process. It was just coincidence that I met Lauren. She was actually visiting my mum, who had a separate case. And to begin with, I was very hesitant to pursue a case on behalf of my child. But my mum, being the protective grandma, she kind of filled Lauren in on our circumstances. And yeah, like I said, 11 years later, Lauren has secured that settlement for us. We've agreed that they're at fault and we're in the next stage of the process. But it's been a very long road. It's been hard, but Lauren has made it the easiest it could possibly be. It's just so important to have a good solicitor that really knows what they're doing, that's passionate about what they're doing, and that you can trust.
That's so true. Sam, can I ask you a question? It's Janet here. Hello. So how long has Kate been a part of your journey, and how easy is it to even find a good case manager?
So Kate isn't a part of my journey. There's a little bit of misunderstanding there. So Kate's a case manager, so she can answer sort of your questions on case management.
Right.
I have a case manager. It didn't. So case manager comes in once. I believe it's for all cases. I don't know, but for my case or for my child's case, it was after settlement. So once we agreed with the trust that they were liable and were at fault, that's when the case manager came on. So only in the last year, so about 10 years from the start of the case to case management for us.
And it was a good match, I hope.
It was a good match. Yeah. So I don't know, I can't talk for everyone, but for us, I was presented with some CVs and I went through them and I chose someone based on their CV. But for me, it was about their background, their history, what their experience was, and a lot of the person that I chose had a lot of interest in their career path, just made me feel that they would be the perfect person. And it's been a very good match. I speak to my case manager very regularly. I'm sure she spends way too much time talking to me about things, calming me down that she shouldn't be, but she is amazing at what she does.
Yeah, they're that go-to person, aren't they, when you've built up that trust and confidence in them, aren't they?
Definitely. You work with so many professionals in this process, and you have to have a professional head on all the time. Even though you're a parent, you still have to be professional. And so the case manager becomes more of a friend and a confidant, someone that you can trust and speak to just about anything. Well, that's what my kind of case manager's turned into anyway.
Oh, brilliant. I'm sorry, I don't know if this is a good time to bring in Kate to talk about case managers.
Yeah.
Hi, Kate, it's Janet here from Snap. Sorry, I have spoken to you, but not.
No, right, yes,
no problem.
Yes, so I mean, I was just going to talk through a little bit about case management, and then if anybody has any questions, feel free to ask me. But I suppose when it's time for a case manager to become involved, you normally would have a meet and greet. So you might be sent, as Sam said, you might be sent a few CVs. Case managers are generally professionals that have been working in a clinical environment and have come into case management. So they might be an MT, a nurse, they might have a psychology background. And you're really looking, I suppose, for somebody that you have a connection with, who has experience that's relevant to your child. The meet and greet meeting is really an opportunity for you to ask them some questions about how they would support you. I often structure it by talking about what I would do as a case manager, what the role is, and often then questions come out of that discussion. I suppose all case managers have slightly different experience and maybe a slightly different style. And as Sam said, I definitely speak to most of my clients every day. It's a can be quite an intense relationship that you spend a lot of time talking to this person and putting trust in this person to get the support you need. So you definitely want somebody that you feel you have a good connection with and that you can work with. So I suppose often one of the big kind of the first area we always focus on is care. It's likely that most of the cases will require some form of care, and that might be from the kind of milder end of needing some support with cleaning or a buddy to go out in the community with, right through to a 24-hour care package for clients with very complex needs that might be fully dependent. And it's the case manager's job to sort of assess that current need for care and what the associated cost will be. And they will normally complete like an initial needs assessment, which will detail all of these recommendations. And we use our clinical reasoning to justify those costs and secure the funding where we can. So once we have authority to proceed with that, we might, and that might be that we have some funding through the claim, through interim payments, or we might also work with statutory services to implement some care. And we will often use an agency, maybe in the first instance, to kind of get caring quickly and supporting quickly. And then often we'll move towards trying to employ a directly employed care team where you have much more choice over who's working in your home. So we'd be involved in the recruitment process, in the induction and training of those carers and supervising them over time. It's quite a big piece of work. We would write care plans and risk assessments in line with the family, kind of cover things like medication, setting up rotas and timesheets and payroll and all of those sorts of things. It's a very important piece of work, having people working in your home, although they're there to support you and to support your child. It can be a really difficult adjustment. So it's important to kind of take it slowly and find the right people, and that's what your case manager can support you with.
Sure. Does Sam, for instance, have a lot to do with the recruitment? Are you there on interviews for support workers, Sam, who come into your home?
So, like I said, I had a look at the CV and I chose the support worker. The initial team around the child, so your physiotherapist, your occupational therapist, again, you do have a lot of say in who you choose, and not one person is going to fit everyone. So you could choose someone, and when they come into the home, you can say, actually, this isn't the right fit for us. And then when it comes to the care package, for example, in our case, we need a buddy. So when we're going to do direct recruitment, so that we can have a really personalised person that really suits all of my child's needs. So I'll be a big part of that process as well. So you are as much as you need to be. If it's too much, you can say, please, can you do this? I can't handle it. But at the same time, if you want to be involved, they are there to work around you. They're not there to work just for you if you don't want them to. They just do what as much or as little as you need. So you can be as involved as you want to be.
Absolutely.
Brilliant.
Yeah, I would agree with that. I've definitely got clients at both ends of the spectrum. Clients who really just do like me to kind of go off and find people and introduce them at kind of the second interview stage, and other clients where it's very much more of a shared case management role, where they still kind of lead a lot of the care related to their child, and both of those are absolutely fine.
Great. Sorry, guys, I think we have some questions coming in. I'm using my mobile, which is not allowing me to see some of the questions. We're also just towards the end of the presentation. Anybody will be able to ask questions to Sam or to Kate, and to Lauren and to Sarah. We will edit it at the end, so anything that's been asked, will be cut out for the final presentation. But I have to, if I can ask either Jade or Jackie to read out any questions that are there. I'm really sorry, my phone is just not letting me click on them. If there are any questions.
That's okay. I've got a question here for Sam, and it's from Sarah. Can you share with us what questions or concerns that you had before you started the legal process?
I was really concerned I'm someone that very much lives in the future. I think many parents with children with additional needs, that kind of is just how we live. You're constantly worried about the future. So for me, it was the same as what I presume a lot of people. It was, how long will this be? What help will there be? What will the outcome be at the end? And when I tried to look up some of these things, there's no information out there. So it's been a learning process the whole way. I suppose the only comfort I had was that our solicitor, Lauren, she was always very honest that it could very well be that we don't get the result we want. But I always felt a trust in her that we would get to where we needed to be, and that trust was proven to be right, because we have. But I don't know, I think in the initial stages, I was in so much of a denial of everything. I was so hesitant to even start the process, because I don't know, I feel like I had this guilt of, I'm his parent, it's my responsibility. So I think that to begin with, it was just a bit of a blur. I just kind of followed the steps, went through the process, and kind of just took it as it came. Sorry if that's not much help.
It's very well answered. Do you have any other questions? No written questions.
Do you mind if I ask a question for Kate?
Yes.
This is something I've discussed with case managers. What advice would you give to parents at the beginning of a case? You know, you see it all, and you don't just see it from a legal perspective like us. Is there anything you can share with us as to what advice you would give?
I suppose, yeah, once you have a case manager in place, use your case manager. They're there to support you. So do ask them questions, do ask them to do things for you. And you know, use your legal team in the same way. They're there to answer any questions you have, any concerns you have. So I think it's getting the right people around you to support your child, and that goes with the therapy team as well. Making sure, I mean, it should be part of the case management role anyway, but making sure that the therapists that are working with your child have the right skills to work with your child. Everyone has different backgrounds, and by building that kind of team of experience around you, it really kind of informs that journey, that rehabilitation journey for your child.
Thank you. Is there any other written questions?
Yeah, there's one there, Janet, from Helen for Sam. So Helen is asking, from a case manager's perspective, what qualities would you look for in a good lawyer? And that's to Sam.
Did you say from a case manager's perspective?
Yes.
I don't know if that question was.
I think probably from your perspective, Sam. Yeah, if you say from your perspective as a parent, what would you look for? What advice would you give?
Personally, I want someone that is very secure in the way that they work, who knows what they're doing. I need someone who's confident, that's going to display confidence in their ability, because you put a lot of trust into these people, you open your lives up to these people, you need to trust that they know what they're doing, trust that they're not just doing it because it's their job, but you want to sense that they care. I mean, for us, 11 years, Lauren's been a part of my child's journey from when he was 1 year old to now being 12 years old. It's a big part of your life to be a part of. So you want someone that does care, that goes that extra mile, that has that, who is professional, but also can have that personal interaction and relationship with. You are sharing so much of your life that it needs to be a good balance of professional and personal.
And then, so I guess, Kate, sort of the same question to you. Sorry, I think Helen might have got the names mixed up. But for you working, what do you really want to see from a lawyer? You know, how do you, you know, how would that relationship work?
Yeah, I mean, I would agree with Sam, everything that Sam said, but also, you know, a lawyer with a good team of people around them as well, where they're responsive and they respond to you, you know, in a timely manner. That's always helpful. Yeah, I think everything. I agree with what Sam said. You're working with people at a very difficult time in their life often. So it is finding that balance between being supportive and also having that confidence to kind of push you a bit when you need to kind of make the claim. So you want to have that experience as well.
Okay, thank you, Sam. Thank you, Kate. That's great.
It is, Sam, such an emotional journey. It's just what Kate's saying there, isn't it? It's not just the legal side of it. It's what you are taking on as a family, as a mum, and letting us all in your life, into your home.
Yeah, you guys get to go home at the end of the day because it's your job, but for us it's a 24 hours a day, and it's not just the legal side of things, it's just the everyday things. Having a child with additional needs is hard for anyone, but when you have the added pressure of this as well, which is by no means a bad thing, it's a good thing, because at the end, if things go well, then you get the help that you need, and there's nothing more reassuring as a parent than knowing that your child is going to be supported. So
Big deal.
I think there's been a question for Lauren, if you don't mind me picking up, saying why has the litigation in Sam's case taken as long as 11 years? Are you okay to pick that up, Lauren?
Yeah, that's fine. So in the case that Sam and I have got together, effectively the difficulty was proving the issue of liability. So we had to collate all of our expert evidence, and in the end we had 5 different experts that were all looking at just whether or not something went wrong during the labour. Then moving on from that, we then had to put the case to the defendant trust in what we call a letter of claim. We had to wait a while for that to come back, that response, which was about a year in itself. They then proceeded to deny everything. So effectively, we then had to start the court process to go through the various steps and directions to exchange evidence and set down a trial date effectively. And it was just a very long fight. So it was defended pretty much all the way. We got within, I think it was 2 months of the trial date itself. It might have been less, Sam. I don't know if you remember.
I think it was less. I think it was maybe a month. I think we November and it was meant to be December. So yeah, it was a month.
And they just continued to deny everything all the way, refused to meet with us, refused to re-engage and everything. It was really only with this court date hanging over them that they then said, fine, we'll meet with you. And after a very long day, a long discussion, we finally did manage to agree that they were in the wrong and they admitted that it was their fault. So that was 2 years ago now. We got to that point, and now effectively we're moving on to look at exactly what Sam's child needs. And again, that process is, for the reasons I explained before, a very long process in itself, because we need to be certain on what the prognosis is before we actually set down what the value of the claim is, which is why it's still ongoing. But obviously, if things had been admitted from the very outset, if they had been willing to meet with us sooner, it would have been much quicker. But you don't know what's going to happen, unfortunately, until you actually put everything to them and see how they respond.
But also, I just think it's important to say as well, even had they admitted very early on, it still would have taken the same amount of time, wouldn't it, Lauren? Because it's so complex because of a brain injury. It's knowing, like Lauren said, what this child needs for the rest of their lives. So there's no good rushing it, because anything could change. In our circumstances, my child's health has changed over the years, and had we have closed his case early, things that now will affect him for the rest of his life, which were a knock-on effect of his brain injury, we would have never been able to take into consideration. So it's not something that can be rushed. It does take a lot of patience for those reasons.
Yeah, that's a very good point, Sam.
The other thing, just to quickly to add, is it is all dependent on the child and the severity of their injury, and it's all dictated by that effectively, because we will never rush it if it doesn't need to be rushed, or it shouldn't be rushed. So it comes down to the individual and to what they actually need.
And we also have the safety net, don't we, Lauren, in child cases, where we can't settle a case unless a court approves it. A judge would have to be satisfied that we've got the right settlement for that child. So the judge would have to be very content that all of our experts were in agreement, and that we knew, and that any settlement we'd achieved was the right sum of money to look after that child for the rest of their life. So there's lots of safety nets in place to make sure that we do our jobs properly as well.
Guys, I just see another question here from Anita, and it's for Kate, Sarah and Lauren. And the question is, from your experience in child cases where the life expectancy may be uncertain, how have case management hours been best reflected in expert reports, and is there a tendency of over or underestimating this?
Yeah, so effectively we, as you say, we rely heavily on what the experts assess that need's going to be. I think in my experience doing both paediatric and adult cases, sometimes it's actually easier with the paediatric cases, basically for the reason we've just been saying, that they go on for so much longer, that you have a much better understanding of what's going to be needed and how case management has played a part in that. So you tend to build up a bit more of a history of the amount of hours and the amount of time that is being spent. And we don't get involved too much in doing the actual predicting. We really would leave all of that to the experts to then look at those records and then come back to us and say what they think is likely to be needed for the rest of that child's life. I think more the role of the solicitor in that is just making sure that the case management notes reflect everything that that case manager is doing, reflects everything that is involved with managing that team, so then our experts can effectively quantify what is going to be needed for the rest of their lives.
Thank you, Lauren. I think maybe Jade has one more question before we just sort of wind things up. This is one of 4 sessions, so we have 3 more coming up. Jade, do you have one more question? Jade, was there one more question? Oh, I'm sorry, I can't hear Jade.
Sorry, Janet. It's
Janet.
yeah.
Sorry, Janet. I was on mute. I'm actually talking to myself. My goodness. Sorry, just to say, Dawn, I know that you've just messaged in to say that you're waiting for a response to David's question. I think that we can't give any further information until Sarah and Lauren have a further conversation with them. But I do notice your question below, and I presume it's for Lauren or Sarah to jump in. So Dawn is asking that if a child or a client has been awarded money for, through the litigation process, but further down the line their package needs further enhancing, is that doable? Is that achievable?
Short answer is yes, possibly. And if we settle a case at a stage when there is a future risk that there could be a deterioration, we can get an order for provisional damages, which means we can go back to the court. So, for example, if there's a risk of epilepsy in the future, but there would have to be a real risk of it happening in the future for the court to agree to that. And again, as Lauren said, we're guided by our experts in that respect. So you'd need a neurologist to give a view that that is the possibility for the future. Otherwise, once the claim is settled, it is settled once and for all. You do have to make that provision, your settlement, that you can go back to court. So there does have to be a risk that it can happen. You have to be aware of that risk to be able to plan in the settlement.
Great. Thank
Anything
you.
to add to that, Lauren? What do you think that's?
Sorry, it's just on mute there. No, I don't think so. I think that's right, is that the general rule is that it probably should be the final settlement. The other thing to bear in mind is the majority of settlements, they don't stop you or prevent you from then going to statutory services if something happens in the future. Normally what will be involved is something called a court of protection deputy, and they can be quite good at then steering and navigating their way through being able to access statutory services, even if the settlement later down the line doesn't provide enough for that child's needs.
Thank you. Thank you, Lauren.
Brilliant. Oh, thanks, guys. I think what we'll do is we'll sort of come to an end now. We've got some fact sheets that we'll send out afterwards. As Sarah had mentioned, if there's quite specific questions that Sarah and Lauren are very happy to discuss that offline. Is that okay, guys?
Yeah,
sure. Yeah.
Super. But can I please say thank you so much, Sam, for coming on today. I think I was more nervous than you were.
I was very nervous.
Oh, well, you did absolutely brilliant. I have to say thank you again for everybody. And I hope it was useful. We have another 3, so we've got information about that as well. But thank you again, Sam, Kate, Lauren, and Sarah. And I hope everybody has a good, safe rest of the day, and we will speak to you all again soon.
Thank you.
Bye, guys.
Thank you. Bye.
Bye.